So the Foreign Investment Act, it is pursuant through Republic Act 7042. And this was enacted back in 1991 and later amended in 1996 by Republic Act 8179. So this is a short law lang guys. 18 sections ang original law and 10 sections for the amendatory law. So I suggest that you read it in its entirety so that you'll have an overall comprehension of the scope that it covers and how it relates to the corporation code, and also how it relates to other special commercial laws like the Public Service Act. So the Public Service Act, guys, I checked the 2024 bar syllabus. It's included. So we will discuss it in our subject. Previously, it was covered in the discussion sa corporation law on nationality of corporations. It's not really a specific jud na topic in SCL. So why do we have this Foreign Investment Act? So the policy of the law is, of course, to attract investors, foreign investors. But at the same time, foreign investment, okay, must still be in pursuit of our national economic policy, and it must still be in accordance with the limitations on foreign investments as embodied in our constitution and other laws, specifically the Public Service Act. So this aims to encourage investments in certain enterprises that we want to develop as a country. So we have a focus here on export industries and agriculture, right? To encourage investment in those identified areas. So we welcome foreign investments because it will supplement Filipino capital and it will encourage as well technology transfer. So despite this law, which provides for certain industries or trade that foreign investment are restricted or are not allowed, okay, there is still this general rule that there are no restrictions on the extent of foreign ownership, even in export enterprises. So you learn later what are these export enterprises. In domestic market enterprises, which are defined in this law, it even encourages 100% foreign equity. So there can be foreign-owned firms catering mainly to the domestic market, and that is through the provisions of this law. So important terms, foreign investment, since this is the Foreign Investment Act, it is an equity investment made by a non-Philippine national, and it is in the form of foreign exchange or other assets. So these investment, whether in money or in other assets, must be actually transferred to the Philippines, and it must be duly registered with the central bank. And the central bank will appraise the value of the assets and the foreign exchange. So foreign investment means that there must be actual transfer of those valuable properties to the Philippines, not fictional. Another important term under the Foreign Investment Act is the definition of doing business in the Philippines. So this is the most important term in this law. There are a lot of decided Supreme Court cases wherein the court had to interpret whether or not a corporation can be considered as doing business in the Philippines. because their rights, the rights of these foreign corporations and their liabilities will depend on whether or not they are considered to be doing business. So as law students and future barristers, okay, who will take the bar, you must memorize this definition of doing business, and you must also take note of the concepts to help you identify whether or not a foreign corporation is doing business. Daghan kaig bar questions, guys, and it just revolves around this topic, whether or not a foreign corporation is doing business. So Section 3D of the Foreign Investment Acts defines doing business as follows. So Ms. De La Serna, can you read it?
Yes, attorney. It includes soliciting orders, service contracts, opening offices, whether called liaison offices or branches, appointing representatives or distributors domiciled in the Philippines or who in any calendar year stay in the country for a period or periods totaling 180 days or more. And another is participating in the management, supervision, or control of any domestic business, firm, entity, or corporation in the Philippines. And lastly, any other act or acts that imply a continuity of commercial dealings or arrangements and contemplate to that extent the performance of acts or works or the exercise of some of the functions normally incident to and in progressive prosecution of commercial gain or of the purpose and object of the business organization.
All right. Thank you, Ms. De La Serna. So the definition also includes exclusions, okay, from doing business. But this is further elaborated in the implementing rules and regulations of the FIA or FIA. Right? Can you read, Mr. Salomon, what is not included in doing business?
Uh, the IRR further does not include the following from the definition of doing business. Number one, the publication of a general advertisement through any print or broadcast media. Number two, maintaining a stock of goods in the Philippines solely for the purpose of having the same processed by another entity in the Philippines. Number three, consignment by a foreign entity of equipment with a local company to be used in the processing of products for export. Number four, collecting information in the Philippines. And number five, performing services auxiliary to an existing isolated contract of sale which are not on a continuing basis, such as installing in the Philippines machinery it has in the Philippines machinery it has manufactured or exported to the Philippines, servicing the same, training domestic workers to operate it, and similar incidental services.
All right. So since the law defines what is not included in doing business, then in addition to memorizing what is doing business, you also need to know what is not included in doing business, because otherwise you won't be able to answer the questions that will be asked in the bar. So the determination of whether a foreign corporation is doing business in the Philippines is based on the facts of each case. So there is this pro hac vice rule, because due to the complexity and sophistication of corporations and the myriad businesses or activities that they can do, okay, it's not a particular ruling in one case will not squarely apply to the same corporation, even though it appears that they are engaged in the same kind of business. Okay, so it must be determined based on the facts of each case. That's why there are a lot of cases on this. Maabot gyud siya even up to the Supreme Court because there's no one case that will fit another case. Daghan kay SEC opinions about this. Because sometimes corporations will seek an SEC opinion on whether they can appoint a foreign director to their board or whether they can hire an alien employee. So in relation to the revised corporation code and the concept of doing business, you need to know that in the revised corporation code, there is this prohibition on doing business without a license by a foreign corporation. So can you read it, Miss Alejandre?
Section 150 of the Revised Corporation Code provides no foreign corporation transacting business in the Philippines without a license or its successor or assigns shall be permitted to maintain or intervene in any action, suit, or proceeding in any court or administrative agency of the Philippines. But such corporation may be sued or proceeded against before the Philippine courts or administrative tribunals on any action on any valid cause of action recognized under the Philippine laws.
All right. Question, Miss Alejandre. From section 150 of the revised corporation code, do you think that a foreign corporation who is not doing business in the Philippines can be sued here or can file an action here in the Philippines if it's not doing business? Miss Alejandre. You can answer it based from the text of section 150. Do you think that foreign corporations not doing business in the Philippines can sue and be sued here?
No, attorney, but only on isolated transactions, attorney.
Are you sure, guys? Because that's the gist of most legal controversies. Not a foreign corporation not doing business in the Philippines. Are they covered by the prohibition in section 150? So maybe you'll change your answer later in subsequent slides, ha? Because we'll discuss section 150 furthermore. Further. So in section 150, klaro ang rule. If you are doing business and you do not have a license, then that foreign corporation cannot sue and be sued. If you are doing business in the Philippines, you are required to get a license. Okay? But there are cases when a foreign corporation without a license who is doing business in the Philippines can be sued. Makasuhan siya. Right? Even without that license. Because if dili siya, kung invoke niya ang section 150, then it will result to an injustice because there can be no remedy against a foreign corporation for its acts committed in violation of Philippine laws just because wala siya license. So there is this principle of estoppel that if a foreign corporation is doing business, it can sue and be sued even though it has no license because of estoppel. Because it, without this exception to section 150, then it could prevent a person from first contracting with a foreign corporation and a foreign corporation contracting with a domestic entity or individual. So there is this doctrine of Estupel. But how about foreign corporations who are not doing business in the Philippines? Are they required to get a license first before they can sue or be sued here? So no, di sila covered sa section 150 because they are not doing business in the Philippines. But they need to file a case in court, maybe for their protection or to make them liable to a domestic entity or Filipino. So pwede sila kasuhan even though they do not have a license as long as they are not doing business in the Philippines. So it is not the lack of license which will bar the foreign corporation from gaining access to Philippine courts. But it will be doing business without the license. But if you are not doing business, then you can access the Philippine courts. Kasabot mo, guys?
Yes, attorney.
Yes, attorney.
Yes, attorney.
So what if the foreign corporation not doing business in the Philippines has a branch office or a representative office? They appointed someone to act in their behalf while they have interest in the Philippines. So it does not matter whether or not the foreign corporation not doing business has a branch office or representative office. What matters is that they are considered to be not doing business. Okay? So this is a summary of the rule in section 150. What bars a foreign corporation is transacting or doing business in the Philippines without a license. So conversely, if you are an unlicensed foreign corporation not transacting or not doing business in the Philippines, it can be permitted to bring an action. Is that clear to you guys? Because we will discuss now cases, decided cases of the Supreme Court. So several factors have been used by the court in determining whether or not a foreign corporation is doing business in the Philippines. They have this continuity of commercial activities or transactions, whether or not there have been repeated commercial activities. When there are earnings or profits derived by a foreign corporation from a particular transaction. So in B. Van Zweden Brothers versus GTVL, an exporter in one country may export its product to many foreign importing countries, but not necessarily performing in the performing country's specific commercial acts that would constitute as doing business. So in these cases, decided by the court, they developed this twin test. Okay, we have the substance test and the continuity test. So substance test means whether or not a foreign corporation is engaged in activities that would show that it has organized a body or substance of its business in the country. While the continuity test taken from the definition of doing business. Kaning keyword yun ni siya. It's important that this be included in your definition of doing business. That they are engaged in any activity that implies a continuity of commercial dealings. The key word is continuity. So under this continuity test, doing business will imply a continuity of commercial dealings and arrangements or performance of acts normally incidental to its purpose and object as an organization. So how do we flesh this out? You can flesh this out by reading the decided cases. So the setting up of gaming servers in the Philippines by a foreign corporation engaged in online gaming constitute doing business in the Philippines. So this is how the SEC resolved this question. So the first requisite under the substances is whether or not it is maintaining in the Philippines a body or substance of the business or enterprise. So this question involves whether or not they have a plant or a factory here. They have a sales store here in the Philippines. They have appointed someone to carry out their business activities. So in this case, ang foreign corporation ani is called Jenny Brain. Since they intended to set up game servers by engaging the services of a local telecom company like the PLDT, then the answer to the first question, the substance test, is a yes. Okay, they are considered to be maintaining or continuing a body or substance of their business enterprise. Because without the gaming servers, without entering into a contract with a local telecom for the maintenance and operation of game servers, then it could not offer its games to Filipino users of the internet. So first test, yes. How about the second test, the continuity test? So in addition to the setting up of game servers, okay, since operational na ang game servers, it implies a continued presence in the Philippines. So that means that Jenny Brain, okay, is already engaged in activities which necessarily imply a continuity of commercial dealings, because through those servers, okay, Filipino users, internet users can avail of their games. So even though there are no physical activities, okay, being done here in the country, but because of its availability in the internet and the maintenance of the game servers in the Philippines, then the commercial dealings with Filipinos are processed and consummated in a virtual plane. So essential ang presence sa game servers in the Philippines to these online transactions. So Jenny Brain therefore is considered to be doing business in the Philippines. So if there is a bar question, there is an essay question asking you to resolve whether or not a foreign corporation is doing business in the Philippines, you have to answer it using the twin test, substance test, and the continuity test. Also remember what are not considered as doing business. There are 8 of them in all. So if you appoint a distributor in the Philippines, is that considered as doing business? So if we go back to what is not included, okay, you take a look here. So number 3, appointing a representative or distributor domiciled in the Philippines, which transacts business in behalf of the foreign corporation. So it is not included in doing business. And in the case of Steelcase versus Designed International Selections, okay, the foreign corporation was not considered as doing business. But ang rule is this. gi-clarify ang rule on distributors. If that distributor is an independent entity which distributes products, not just the product of the foreign corporation, but also other products on its own name and its own account, then that's what is not doing business in the Philippines. Katong foreign corporation nga gisupplyan tong distributor. But if the distributor is under the full control of the foreign corporation, then that is considered as doing business on the part of the foreign corporation, the supplier. Is that clear?
Yes,
So,
attorney.
clarify sa steel case that di ka ma-consider as doing business as long as you are not in full control of the distributor, the local distributor in the Philippines. So in Cargill versus Intra Strata Assurance Corporation, the court clarified that doing business essentially means, okay, profit making on the part of the foreign corporation. So what if si foreign corporation nag-purchase ra day siya o products from a domestic corporation? Then it is the domestic corporation who in fact derived profits from the transaction. Then that is considered not doing business. So in the Cargill case, the activities of the foreign corporation was considered to not bring, it did not bring any direct receipt or profits to the foreign corporation. So other factors that the court considered when they ruled that the foreign corporation was not doing business is that it did not have any office in the Philippines. It imported products from the Philippines through its non-exclusive local broker. And the local broker is an independent contractor and not an agent of the petitioner. So it's important that when a foreign corporation appoints someone to act in their behalf in the Philippines, okay, that appointed person must not be solely under the control of the foreign corporation. That appointed person must in fact be carrying out an independent business. So in Pioneer International versus Guadis, okay, the foreign corporation invested in a domestic corporation, but at the same time, it appointed a Filipino to oversee that corporation where it invested in. Kay magtukod sila og bag-ong plant. So, is the appointment of that person to establish a concrete plant and to oversee the operations of that plant, does that act constitute as doing business? So in this case, the court said yes, it was not a passive investor in the domestic corporation because it in fact appointed a Filipino to oversee the operations of the new plant. Right, so that's the important points in doing business, the definition of doing business. The kay bar questions, ani guys, let the most recent one that was asked was back in 2018. Tanawan ni ang 2018 bar question. I'll show it to you. Ako na to be kung maka-answer ba mo? question number 7 in the 2018 bar. Can you see it? What I'm sharing?
Yes, attorney.
Yes,
Or-
attorney.
So Yelp Pictures, it's a movie production company based in California. And they entered into a contract with Yehe Movies, a Filipino movie production and distribution company, wherein that Filipino corporation will be the exclusive distributor of the films produced by the foreign corporation. So they executed a film distribution agreement. So the first question is, may the acts of entering into the film distribution contract, the subsequent execution and performance of the terms of the contract in the Philippines, and the appointment of Attorney Ison. So Attorney Ison here was appointed as its attorney in fact, its local lawyer. Will this be considered as acts of doing business in the Philippines that will require Yelp Pictures to register as a foreign corporation and obtain license to do business in the Philippines? Kaya answer ninyo, guys.
No.
Why no?
Distribution. Appointment of distributor is excluded in the list of doing business.
Right, so no, then you give your second paragraph, your legal basis will be a definition of what is doing business in the Philippines. And then you include there, not included in doing business is the katong third na appointment of a distributor na non-exclusive distributor independent from the foreign corporation. So here, in the facts of the case, do you see any circumstance here showing that Yehe Movies is under the control of Yelp Pictures? Na ba? Because that's the rule when there is appointment of a distributor. Foreign corporation must not be in control of that local distributor.
The movie is owned by Dick Jansson.
Okay, and 85% owned. Okay, but there's this fact stated in the question that Yelp Pictures has an option to acquire up to 40% of the outstanding capital stock. So muna siya ang mga style sa examiner, guys. They will add something to trip you up. Confident kayo mo sa imong answer at first. Yeah, pagbasa ninyo, uy, do I consider this in my answer? Oh, Mr. Umpad, what do you think?
Option naman siya to. So, wala pa
not-
siguro control.
It's not shown here that Yelp in fact exercised that option. So we're just interested in the fact that 85% of Yehe Movies is owned by a Filipino and the rest is owned by the public. So this is a publicly traded corporation, Yehe Movies. So yes, we will still answer that Yelp Pictures is considered to be not doing business in the Philippines. How about the appointment of Attorney Ison? What is the bearing of his appointment to your answer? How do you deal with that? So when a bar when a bar question ask you like this, guys, you need to address all the points covered by the question. You need to address that mere execution of the film distribution contract and the appointment of the attorney in fact, okay, is not considered doing business in the Philippines, considering that it merely appointed a local lawyer to protect its interest, okay, but not in pursuit of its uh continuity of commercial dealings in the Philippines. So dili gihapon siya considered as not doing business in the Philippines. So most bar questions are framed like that, guys So from the FIA, you need to memorize, Jod, what is doing business in the Philippines and what is not doing business. And also memorize the substance test and the continuity test. It will help you answer bar questions. Okay, let's resume our discussion of the FIA. So the FIA also defines export enterprises. So this is an enterprise wherein a manufacturer, processor, or service enterprise, including tourism, exports 60% or more of its output, or wherein a trader purchases products domestically and exports 60% or more of such purchases. So kung 50% ra ang iyang export attorney, export enterprise, iya. 50%. The answer, guys. No. Okay, it will not be considered as an export enterprise. What if exactly 60% of its
Enterprise.
output? So exactly 60. So 61 up, 60, 61, and upwards. If it is being exported, then they fall within the definition of an export enterprise. How about a domestic market enterprise? So this kind of enterprise produces goods for sale or render services to the domestic market entirely, or if exporting a portion of its output fails to consistently export at least 60% thereof. So those not falling within export enterprise are considered as domestic market enterprises. Sabot? Nakaabot
Attorney.
60% or more output, then they are considered as domestic market enterprises. So under the FIA, there are two kinds of enterprises considered here, the export enterprise and the domestic market enterprise. So non-Philippine nationals or foreign corporations are required to register. Okay, where do they register? They register with the Securities and Exchange Commission and other related agencies, depending on the nature of their business. So general rule is that a non-Philippine national can do business as defined in Section 3D, or they can invest in a domestic enterprise up to 100% of its capital, as long as they register with the SEC or with the Bureau of Trade Regulation and Consumer Protection of the DTI for single proprietors. Okay, exception. If the participation of the non-Philippine national in the enterprise is prohibited or limited to a smaller percentage by existing law or under the provisions of the FIA, the Foreign Investments Act. So the rule here is that up to 100%, pwede sila mo invest. Okay, as long as they are registered accordingly. Exception is when there is a limitation on the amount that may be invested. So there is this prohibition on imposing any limitation outside of what is imposed or prescribed by the Foreign Investments Act. If any enterprise seeks to avail of the incentives of new investors or kaning innovative na mga investors, then they can apply with the Board of Investments under the Omnibus Investments Code. So if a non-Philippine national will engage in the same line of business with an existing joint venture, wherein in that joint venture, majority shareholder, si non-Philippine national, then that fact must be disclosed, including the partners of the non-Philippine national in the existing joint venture. So mandatory disclosure with the SEC. So who are Philippine nationals? Under the FIA, they are any citizen of the Philippines, domestic partnerships or associations wholly owned by citizens, corporations engaged under the Revised Corporation Code, wherein 60% of their capital stock outstanding and entitled to vote is owned by citizens of the Philippines. Those corporations engaged, organized abroad and registered as doing business in the Philippines, of which 100% of the outstanding capital stock is wholly owned by Filipinos, and a trustee of funds for pension and other employee retirement, where the trustee is a Philippine national, or at least 60% of the fund will accrue to the benefit of Philippine nationals. So in summary, guys, in the IRR, this is what Philippine nationals must comply with to be considered as a Philippine national. Lo, did you say something, guys? Am I audible?
Yes, Attorney.
Yes, attorney.
So 2 conditions to be considered as a Philippine national: at least 60% of the outstanding capital stock and entitled to vote. And at least 60% of the members of the board, okay, must be citizens of the Philippines. So 2 conditions to be considered as a Philippine national under the Foreign Investment Act. Corporation should be registered as doing business in the Philippines as well. So the Foreign Investment Act provides for a list. They have this foreign investment negative list. It is found in Section 8. And there are 2 lists, List A and List B. So what's the rule when, I'll show you later the list in a later slide. So what's the rule on foreign investments in export enterprises? So you'll find it in Section 6. So these export enterprises, which are non-Philippine nationals, are required to register with the BOI and they must submit reports that they are required to submit. Then if the BOI finds that that export enterprise fails to meet the export ratio requirement, katong 60% or more, then that enterprise will be considered to be a domestic market enterprise. So the SEC, either the SEC or the BTRCP of the D2I shall issue an order on the non-complying export enterprise. And that order will include reduction of the sales of the domestic market to not more than 40% of its total production. If there is failure to comply with that order, then it can result to cancellation of its registration with the SEC. So why are they controlling, guys, the classification of an enterprise as an export enterprise? Why do you think they control siya? Why are they why is the government interested in controlling the classification of export enterprises, and why is our law requiring compliance with the export ratio? What's the policy behind that? Can anyone guess? Make a guess? Kisa may mga negosyante dali.
To protect the local industry, attorney.
That's one. What else can you think of?
Maybe for tax purposes, attorney.
Yeah, daghan kinig incentives ang ganing mga export enterprises. So they could have tax holidays, tax reliefs. So they must prove that they are compliant with the export ratio requirement in order to be classified as an export enterprise. So you can also read in the law what export ratio means. Okay, so just a matter of reading, guys. So in domestic market enterprises, foreign investments is allowed up to 100%, subject only to the restrictions in the Constitution and other laws, and to the foreign investment negative list found in Section 8. So a domestic market enterprise can later change its status to an export enterprise if for 3 years it consistently exports 60% or more of its output. So this is the another important feature of the law, the foreign investment negative list. It has two component lists, List A and List B. So List A are the areas reserved to the Philippine nationals by mandate of the Constitution and specific laws. So that's why you need to know the definition of Philippine national. Okay, si Philippine national ra ang maka-invest in List A enterprises. List B, okay, are the areas that are regulated by law. So typically you'll see in this list, in List B, mga areas na defense related which requires prior clearance from the Department of National Defense. So for example, any manufacturing of firearms, ammunition, and other weapons, okay, used by the military and our armed forces. Then these are also areas that have implications on public health and morals. So this includes manufacturing of dangerous drugs. Also, kaning operations of nightclubs, bars, beer houses. So in List B, the general rule is that small and medium-sized domestic market enterprises, if they have paid in equity capital less than $200,000, it is reserved to Philippine nationals. Kasabot mo aning paid in equity capital. So this will be their subscribed capital stock actually paid. Okay, di ba? You can subscribe to capital stocks, but sometimes you are not yet fully paid of your subscription. So only those paid subscribed are capital are counted, considered as paid in equity. So that means if nabayaran na to ang subscription, that is already transferred to the corporation for the use of the corporation. So na siya available na capital. So general rule is if you are a domestic market enterprise with paid in equity less than $200,000, then it is reserved to Philippine nationals. Exception will be if there is a minimum paid in capital of $100,000, then it can be allowed, they can be allowed to non-Philippine nationals as long as they prove that they involve advanced technology determined by the DOST and they employ at least 50 direct employees. So these are the requirements to invest in List B. Kagets mo guys? General rule, exception. So this List B, annually actually, ikuha ni siya through an executive order. The Office of the President will issue the list. It is updated, if not annually, every 2 years. And it can also be amended, okay, upon recommendation of the Secretary of National Defense, Secretary of Health, Secretary of Education and Sports. But it requires endorsement by the NEDA and eventually approved by the President. So mo issue ni sila og EO ani or Presidential Proclamation. So the foreign investment negative list, okay, upon enactment through an executive order becomes effective after publication in a newspaper of general circulation. And the list shall be prospective in application. So if an investment was already made prior to the effectivity of the list, then that prior investment, okay, will not be subject to the restrictions imposed by the list. So here's the summary of the negative list. So you need to know this, guys, sad. Daghan kay memorize sa FIA. But this is covered also in constitutional law. Okay, sa natural resources na part. Unsa na siyang article? Article 12. Okay, so you need to have a mnemonic on those industries na 100% Filipino ownership jud ang required. So we have mass media, except recording. We have the practice of profession. Retail trade, but with paid up capital of less than $2.5 million. Cooperatives, private security agencies. If the industry requires utilization of marine resources in archipelagic waters and the territorial sea, as well as in the exclusive zone, rivers, lakes, bays, lagoons. Ownership, operation, and management of cockpits. 100% Filipino-owned na siya. Sugarol gito, no? Kaya gibutang jud siya sa negative list. Then we have the manufacturing of nuclear weapons, anything related to nuclear weapons, firecrackers and pyrotechnic devices. 80% Filipino ownership, private radio communications network. 75% Filipino ownership, private recruitment, kanina recruitment for employment abroad. when the industry involves contracts for construction and repair of locally funded public works, so government projects, except infrastructure projects under the BOT law, which allows foreign investors through partnerships, joint ventures, and foreign funded projects, and construction of defense-related structures. 70% Filipino ownership, advertising. Naani siya sa constitution, no? Nya kanida ka na kaayo. Okay, just for purposes of introducing you to it. Can you read it, Miss Gemoto?
Good afternoon, attorney. 60% capital stock, Filipino ownership. First, manufacture, repair, storage, and/or distribution of products and/or ingredients requiring Philippine National Police clearance, firearms, ingredients used in making explosives, etc. Second, manufacture, repair, storage, and/or distribution of products requiring Department of National Defense clearance. Third, manufacture and distribution of dangerous drugs. Fourth, sauna and steam bath houses, massage clinics, and other like activities regulated by law because of risk posed to public health and morals. All forms of gambling except those covered by investment agreement with PAGCOR. Domestic market enterprises with paid-in equity capital of less than the equivalent of $200,000. Domestic market enterprises which involve advanced technology or employ at least 50 direct employees with paid-in equity capital of less than the equivalent of $100,000.
Okay, thank you. So that concludes our discussion of the PIA. Next meeting, I'll show to you the questions asked about the Foreign Investment Act. We'll end here. Next week, we'll discuss the FRIA and the Public Service Act. So I'm still finishing the reading assignment for the Public Service Act. So see you next week, guys.
Thank you, attorney.
Thank you, attorney.
Can you
Thank
type
you.
Can you type your names?
thank you.
Don't leave yet. Type your
Thank you,
name in the
attorney.
chat box for your attendance today.
Sa JC, attorney, or dili sa chat box?
Chat box. Here. Once you type your name, you can leave the group chat, the Zoom call.
Attorney, we have a question, attorney.
Thank you, attorney.
Hello, attorney.
Yes.
Attorney, we have a question. Next week is Holy
For our
Week. Do
scheduled
we have an
midterms.
online
Oh, let's meet during Holy
or
Week.
online?
Online lang. Online.
Online lang, attorney. Thank you,
Yes.
attorney.
To catch up on the coverage.
Thank you, attorney.
Noted, attorney. Thank you.
Thank you.